Can you prove injury causation in court? Imagine trying to prove that someone's actions directly caused your injury. It might sound simple, but in court, showing this link is often the most challenging part of a personal injury case. When someone gets hurt, the court needs to see clear proof that the defendant's conduct actually caused the harm. This is what we call causation. Without it, even if the defendant was careless, you can't win your case. To prove causation, you need to show two main things. First is cause and fact, also known as actual cause. This means demonstrating that the injury would not have happened if the defendant hadn't acted the way they did. For example, if a person runs a red light and hits your car, you need to prove that if they had obeyed the traffic signal, the accident wouldn't have occurred. The common way to do this is with the invalid test asking, but for the defendant's actions, would I have been injured? If the answer is no, then cause and fact is established. The second part is proximate cause, or legal cause. This asks whether the injury was a foreseeable result of the defendant's conduct. It's about whether the harm was close enough in connection to hold the defendant responsible. For instance, if a reckless driver causes a crash that injures you, and that crash was predictable based on their behavior, then proximate cause is likely proven. But if an unexpected, unrelated event caused your injury, it might break the chain of causation. In court, proving causation involves gathering different types of evidence. Medical records show your injuries and their severity. Eyewitness testimony can describe what happened. Accident reports provide official details. Expert opinions, especially from medical or technical specialists, help explain how the defendant's actions led to your injuries. The key is showing that the defendant's conduct was a significant factor in causing your harm. It doesn't have to be the only cause, just a material one. Without proof of causation, even if the defendant was negligent and owed you a duty of care, you cannot recover damages. The court needs to see a logical, factual connection between the defendant's breach and your injury. This means your evidence must clearly link the two. You want to tell a story that shows how their actions directly led to your harm, step by step. In practical terms, this means collecting detailed evidence about the incident, the injuries, and the timeline of events. Demonstrate that your injuries weren't caused by some unrelated factor. Use expert testimony to clarify complex medical or technical issues. The stronger your evidence, the better your chances of proving causation in court. Remember, causation is a fundamental part of winning a personal injury case. Courts relying on clear, convincing proof to decide whether the defendant's conduct caused your injury. If you can do that, you stand a good chance of getting the compensation you deserve.